Members of the subcommittee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or an appearance of conflict. If anyone needs to recuse themselves from this portion or any scheduled portion of the agenda, if you'll raise that at the time. Let's see, the April 1 minutes are attached. Are there any corrections to the minutes that need to be brought before the subcommittee at this time? Hearing none, all in favor of approving the minutes as attached to the agenda, signify by, how are you going to do that, Savannah? You got a poll function? You got it? All right, signify by thumbs up or?
Yeah, I think they can just use the reaction.
The hand signal. Okay.
Check yes or no, and I'll take a tally.
Okay, very good. Any no's?
No, I have 5 thumbs ups and check marks. Okay,
very good. Well, that'll tell us how we'll have to vote if we're going to vote on anything else today. The assessment areas, item 3 on the agenda, remain the same. We still got the 4 cardinal points that we're pursuing at this time. So unless there are any suggested additions or deletions at this time, we'll move to input from stakeholders. We had pretty much covered a broad swath of ground at the last meeting. There's still a few that are still out there, but there are no new reports that we need to bring before the subcommittee at this point. Item 5, information survey. We'll spend a little time on this. First of all, I want to thank Savannah and Cameron for all of their hard work. I've heard from a number of you on the survey itself, and that has been real good. They have taken it, passed it through Peter Bolak, which Savannah will talk about in just a minute, and you've got a link to it on your agenda, so you can see it in draft form as it will go out from SurveyMonkey. I've been in touch with several of the folks that we want to use to deploy the survey when it's time. We know already that all the state bar counselors will get the survey. That's been approved. The North Carolina Bar Association is on board with this. I discussed that with Jason Hensley in advance of the last meeting. Since then, I have reached out and contacted the advocates, the Association of Defense Attorneys, Association of Black Lawyers, and Association of Women Attorneys. And I have heard positively. In other words, I have spoken with everyone except Kim Crouch. I've left her a message and sent her a letter, but she's not yet confirmed with me that they're on board. But everybody else is, and so Savannah and Cameron will take the helm on the implementation phase. All right, that's enough from the chair. The expert on this is Savannah, and I'd like to turn the mic over to her for items B and C on the information survey. Savannah?
Thanks, Gordon. So I included a link in the email with the Zoom information for today to the preview of the survey. I hope that everybody was able to look at it. We made a few tweaks to give choices to not leave so many places open for our data collection to be a little bit more difficult. So does anyone have any issues with the way the preview of the survey looks for now? right.
Then I think I think it flows very easily.
Okay.
I took it this morning and I thought it was helpful. I also like the ability to comment on every question, whether we get them or not, I guess remains to be seen. But to me, it was very user friendly, I guess, to use a computer interface word.
Perfect. Thank you, Walter, and thank you for suggesting that we put a general comment question at the end to see what our lawyers are going to say about the work of this subcommittee and give us some other ideas. So for the survey deployment, like Gordon said, he's already reached out to so many of the leaders at the organizations that we would like to send the invitation to take this survey to. So in his kind of letters to those leaders, Gordon indicated that Cameron and I will reach out to them. Cameron and I will put together a template email to be sent to the leaders so they can put it on their listserv and say, and clarify to the members that they send it to, you might get this in multiple divisions, only take the survey once. And we'll hope to do that maybe by the end of next week. I'd like to get it to the council. If we all agree on the survey today, we'll send it to the council so we have a test group, and then go ahead and send it to the other organizations that we've talked about.
Savannah, I think that's a good plan to go ahead and get it out. Start first with I don't want to call us the control group, but I guess we're the regulatory group, and see what we get, and then go forward with the with everybody in the various groups, affinity groups that have been identified. A question that we discussed, and I'd like to get input from the committee on this, is how long do we leave the survey open for response? Savannah, what was your recommendation?
My recommendation was probably about 3 weeks. And that's sort of me planning on my own availability to really devote much time into analyzing the responses that we get, putting it somewhere around the beginning of June. But that's up to the committee. I don't know if anybody's going to be taking this survey 3 weeks after they get the email with it included. And I'm not sure if we're going to be asking the leaders of our affinity groups to send a reminder email at some point. That's something we could discuss doing if we don't feel like we got enough responses at our June meeting. So I'm open to the committee's suggestions, but I was thinking about 3 weeks.
What does the group think about that?
I think that's a reasonable time to me. I think that makes sense. I had one suggestion. I think it's question 6, Savannah. It says, what effect did secure leave have on your mental health? And right now there's 2 bubbles, I have not taken or no effect. And then we have a comment for effect. I think it would be useful to have something that says it improved, my mental health. I still want the comment. I mean, so I think we want the written, but right now there's no way to, if I'm busy, there's no way to simply say it was helpful without providing comment. So I think that I'd like to see a 3rd bubble there on number 6.
Okay, that's great. So we'll go ahead and put one that says it improved my mental health.
Yeah, or words like that. So.
Thank you, Mark.
Any other suggestions on content or on the duration that the survey will be open? So is the subcommittee ready to make it a go to the bar counselors? And then and if there's anything that we learn from that's material that we need to consider, we'll pass it by the subcommittee by email. And we'll do, if everybody's comfortable with Savannah's suggestion, we'll do 3 weeks for holding the survey open. See if we can get as much as we can. Now, I hate to interrupt this agenda, but there's from GNN, which is the Gordon News Network, there's breaking news. Email from Kim Crouch at the Advocates. Thank you for reaching out to me. I am happy to participate in this effort and look forward to working and receiving the survey. So it's 100%, folks. And I'd say with the addition of the Advocates, we've got a good balanced group of potential respondents out there, and this should be a very meaningful exercise. So there are no commercials, however, on the GNN network. Back to the agenda. Anything else on the survey, Savannah, that you want to mention? Cameron, you've been a big part of it too. So if you've got anything to say on that before we leave that and go to
I think Savannah's
looking at a couple of other jurisdictions.
Yeah,
I'm going to go ahead. Sorry, go ahead.
No, I'm fine. I think that maybe a week and a half or 2 weeks in, Gordon will report to you and let you know at least how many people have taken it. And maybe at that point, you can direct us as the chair as to whether or not we should ask the leaders of those affinity groups to send another listserv email.
Okay. I think that's good. And then keep reminding people, I've seen that done before, and it helps. On second or third try, even I sometimes answer surveys.
I was just
Cameron,
getting ready to, excuse me, I was just getting ready to add in that if it's going to be open for 3 weeks, I think there need to be some reminders, whether it's after 1 week, 2 week, or whatever, to people get busy and things go down the list, so to speak. So I think a reminder is a good thing.
Thanks, Mel. Cameron, did you have a comment?
No, sir.
Okay. Well, we'll move on to item 6 then, which is the Cameron Lee show. We've got a couple of other jurisdictions he wants to mention to you that he's looked at and add to the amount of factual material we have on what people are doing in other places. All right. It's all your show, Cameron.
Thank you, Gordon. I'm sorry that I had to cut my video. My internet keeps crapping out, so hopefully it'll be stable through my little presentation here. As Gordon said, we did dig up information on a few other jurisdictions, namely Texas and California, and we've listed them in that order, but I'm going to go ahead and start with California. California doesn't have a uniform rule. I didn't even find local rules governing attorney leave, but I did stumble upon a few articles that discussed notices of vacation, which apparently is a thing that attorneys will frequently do in the state of California. And there's no authority under which they file them. It's simply an advance notice submitted to the court and to opposing counsel. I think it's more a matter of professional courtesy. I understand that these notices are frequently honored, but no party is bound to honor them. So that's about how they handle things in the state of California. Texas, the Texas policies I found were a bit more comprehensive. There was no statewide policy, but I found rules in a number of districts within the state of Texas governing attorney vacation. And in your materials is a copy of the rule from Fort Bend County, Texas, governing attorney vacations. You'll note that there are 2 tiers of vacation: summer vacation and all other vacation. Summer vacation is apparently a higher form of vacation. Anyway, in general, an attorney is entitled to not more than 4 weeks of vacation per year. And during those weeks, the attorney is protected from trial and from pretrial proceedings. Although you'll see, as between summer vacation and all other vacation, the levels of protection afforded are a bit different. Now, this rule only applies to instances in which the lead counsel files a request for vacation. And under the Texas rules of general practice, lead counsel is just the first attorney to make an appearance in the case. with summer vacation, which we can call tier 1 vacation, the most special and the most important. Summer vacation is any vacation taken during the months of June, July, or August. Notice for summer vacation or designation must be filed by May the 15th preceding the vacation. And during summer vacation, sacred summer vacation, the attorney is protected from trial, even if the trial has already been calendared. Now, the non-summer vacation is vacation taken during all other months. This is the lesser form. The designation for non-summer vacation must be filed by February 1st of a given year. And non-summer vacation only protects an attorney from cases not yet calendared for trial or for hearing. And unlike summer vacation, which presumably you could take 4 straight weeks of summer vacation, non-summer vacation may only be taken in 2-week increments. And now I'll note, I haven't surveyed every county in the state of Texas or every district in the state of Texas, because as all of you know, Texas is very big. But I did find that this policy was not uniform across the districts. In Harris County, for example, which is where Houston is, family law practitioners may take summer vacation, but they are not protected during summer vacation from trials that have already been set. So maybe you go down to the coast, but you have to drive back up to try something that was set before you filed for your vacation, which would, I don't know why they chose to single out the family law attorneys. I'm glad we don't do that up here. I will say this, beyond those jurisdictions, I found a number of reports, and I found these after the fact. So I'll include these on our minutes from well-being committees from a few states. And most interesting to me were the reports by the well-being committee from I guess the Texas Bar in 2018, wherein they recommend a discussion on the feasibility of creating secured leave policies, uniform statewide secured leave policies for lawyers. And then a report from Massachusetts in 2019, and this is a special committee created by the Supreme Judicial Court. And I have theorized to Gordon and Savannah during our conversations, and I think I've mentioned it during our meetings as well, that I think that North Carolina may be at the vanguard of statewide attorney leave policies. And this Massachusetts report kind of confirmed that. One of the recommendations of the report was that there be a commission to study the feasibility of implementing a secured leave policy a la North Carolina. And in the report, they reference the state of North Carolina, and they attach a copy of Rule 26 as an appendix. So it sounds like we're more the model for other jurisdictions, which I think is kind of cool. I think that makes our work a little more meaningful. And I'll keep a weather eye open for other jurisdictions. I'll say I also did some research into West Virginia, Illinois, Oregon, and South Carolina, and I have yet to turn anything up on those states. I did reach out to a friend who practices down in South Carolina. I'm hoping to get some more information from him. So unless anybody has any questions, I'll shut up for the present.
Are there any questions of Cameron on what he's reported? There may be pieces of other folks' policies that may be probative of what we're doing. So please keep these in mind when we initiate our look at the Rule 26 policies themselves. Is there anything further on this topic from the subcommittee members? Cameron, thank you for your research. I think what you've uncovered about these Texas policies being a work in progress with some statewide attention being focused on them now is of tremendous interest. And I think imitation sometimes is the highest form of flattery. So go Massachusetts. This is all interesting. Let's go on to item 7. This is really just an abstract of Rule 26 to help us start having substantive discussions of the policies and to see what you might think about whether the policies as stated are are worth keeping the way they are, whether there's any support for change or modification in certain ways. And we can go through this in any order you want. I just thought in order to make it more efficient, if we can just break down Rule 26 into its component parts, we might be able to cover the entire landscape in one or two or maybe three meetings. I'm still going to try to adjourn if we can after 1 hour of worth of work on this, so we don't have to finish this list today. But I had a very wise person advise me after our April meeting, is when are you going to get to the meat? He will go unnamed, Mel Wright, but that's okay. He never wants the publicity for himself, Mel Wright, but it's he's right. It's time, after circling around this and getting our sea legs, we do need to get on with the actual discussion of the policies and what prospects there are for tweaking or not. So let's, is there any comment before we delve into this? And Mel, that was a Gordon Brown way of thanking you very much for making sure that we stay on track here, because I know you are working parallel to this with a number of important things in your day job. So the fact you could be here with us today and keep giving us guidance is very important. If there are no comments at this stage, the first item on this starts with the definition. And the definition of leave period is 1 complete calendar week. It only applies in superior and district courts, no other tribunals at this point. So let's, anybody want to take in or take on the question of whether a leave period should be a complete calendar week? For example, my darling daughter got married a few years ago. I had to take an entire week in order to get a day and a half. Others, I'm sure, have been faced with that in other ways. Let's have some discussion on this.
Yeah, I don't think it should be limited to a 1 week period. I mean, I think the problem you identified is true. You may only need a couple of days, but you really want to file it. And I think that, and you have to use up one of your 3 weeks, even if you're taking only 2 days, which I think is a problem. The other problem that I'm not sure, what if it's a week and a half? I may have a 10-day trip planned, and now I've got to take 2 of my 3 secured leave periods for a 10-day trip. So I don't see, I assume it was done that way for the administrative tracking convenience, viewpoint. But as we'll talk about later, I mean, I think really the attorneys should be the ones tracking how much secured leave they've submitted. So if I want to use 10 days in one period and 2 days in another, I think we should have a total number of days and let the attorneys decide how to use those days, would be my reaction. So.
I only want to play devil's advocate to that, Mark, because I agree with you. But one of the problems that we had in domestic court in Johnston County, for several years, we would only have domestic court 2 days of every week. And we had a couple of attorneys who, despite the way the rule was written, in order to sort of advantage their client to not having a hearing, they would set secured leave for the next 5 or 6 weeks, 2 days at a time, so that then you couldn't get into court. And so I think that that's one of the only problems I see with doing it on a daily allocation, would be that sometimes that could be, besides it being hard to track, could also present some disadvantages to cases that do need to get into court, and the attorney uses something that is personal to the attorney as a way to gain an advantage for a client.
Yeah, I could certainly see that abuse as being a problem. And maybe what we can maybe think about ways to prevent that. I mean, maybe, and I think, the one that comes immediately to my mind is you perhaps limit the number of days or leave submissions in any one, period. Like you can only do one leave per month, or or even one leave every 2 months, something like that. In other words, you couldn't just stack it up to say, I'm taking 2 days, 6 weeks in a row to block. There's a bigger problem, right? If they're really using it for strategic advantage in the case instead of a personal proper leave, that is certainly abuse. Although I agree with you, I imagine tracking and proving that is going to be difficult, right? We're not going to have private investigators following around to say, did you really go on vacation, or were you working in your office on the day of secured leave and you were just trying to get out of a court appearance? So I do. I mean, I think that is a problem maybe we talk about, but I know I hear that, and that is a good point. I mean, I don't practice in family court, but you could see that in small counties too. The beginning of the week is typically when that general civil call is going to be too. You may not need secure leave on Fridays in a lot of places that may not regularly schedule hearings there. So you can, you save up days by only taking the Monday through Wednesday in some courts.
I guess just one observation. I don't practice in the family court, so I don't know how often that leave policy may be used or abused. I would be shocked that a lawyer uses their own personal leave to advantage a client, but I guess it's possible. I would hope also that it's extraordinarily rare, because I would not like for us to fashion rules that assume the lowest common denominator, that we've got one abusive lawyer in one district who gets a lot of attention, and fashion our rules to try to stop that lawyer from abusing it. I think there are other ways to deal with that lawyer. I think we're heading down a dangerous path if we, try to suggest overall statewide rules because we know of one particular abusive lawyer. They need to be dealt with some other way, it seems to me.
So I just want to speak for at least Wake family. I think the standard here is people are going to designate whatever leave they want, and they're not going to book it by a week. Our calendars don't work that way. So if, depending on how you were trying to travel, you could easily eat up 2 weeks just to get 5 days if it spans. And if somebody wants to abuse it, they're going to abuse it regardless. But so to me, I just think the concept of putting it in 1 week isn't really consistent with how people would use it for vacation. Same for, I think I may have been the only one who answered that. I've had to use secure leave for surgeries. And sometimes you may just have an in and out procedure where you have to be out 2 days, but you have to take a whole week. So I'm resting up to my surgery because of the definition. That just seems silly. So I think some flexibility in how it's defined, and maybe we don't break it down to you can only allocate 1 day. Maybe we say it has to be a minimum of 2 or 3 or something like that. But more flexibility, I think, would be more helpful. And I agree with what Mark and Walter have said, and agree with Dion's concerns. I just think we try to bookend it as much as we can.
What are the thoughts on flexibility within 1 day tranches or 2 day tranches, or whether there's some kind of combination that may work? What do you think?
I'd be supportive of at least a 2 day minimum. I mean, you're taking the time to fill out the form and track it and stuff. So I think, doing it truly day by day, I think a minimum of 2, I'd be persuadable to have a minimum of 3. I think that makes sense to have something so it's not literally day by day or filling it out for every Friday or something else. Now, I am sensitive to the fact, I know there's some scenarios where people are taking off 1 day a week for a medical procedure or something else, right? And that is the countervailing argument is, yeah, I've got to go in for dialysis or I've got to go in for a procedure once a week for the next 8 weeks. And if you make me take 2 days or 3 days, that's going to really limit that. So I don't know how common that scenario is, but but I guess my thought would be, a 2-day minimum may make sense. But then you can take for as long as you want. So it's two to the end of your leave, for however many days we decide we want to give. I mean, I guess right now it's 15, it's for 3 weeks, so it'd be 15 days. I know we're going to talk about the total duration. I think I'd encourage us to consider somewhat longer period, but whatever that period is, you could have a minimum and then a max of how many days you have left.
I would agree with 2 or 3 days, but I also think we ought to consider perhaps a paragraph that defines if you have a medical leave or medical need and you're going to have surgery or you're going to be out for a few days, maybe we shouldn't include that with the vacation time. And let's put medical problems and issues maybe in a different category. We don't want somebody necessarily losing their vacation time if they have to have some form of surgery.
I like that idea too, Mel. I think that's interesting. Have we ever had, obviously companies have medical leave policies. We've never done anything kind of a separate medical leave thing in terms of court appearances, to my knowledge. Do we know whether anybody else has looked at that or done that? That makes a lot of sense to me, right? I think in practice, if you're in the hospital, right, the judge is probably going to continue the hearing for those kind of things. But there are a lot of other medical gray areas where, for planned surgeries and other stuff, you may get a different treatment. So I think that is a really smart idea.
Yeah, and it sounded like Catherine was taking vacation time for medical purposes. And I just don't think that was the intention of the rule. I think we ought to make an exception for that.
Well, I like the idea of then being able to parse out kind of like how Texas did with the sacred summer vacation. Because with medical situations, you're either going to wait or, wait until your calendar clears up and set your medical procedure, which is, I don't think what we want to do. And maybe we can allow medical leave some more deference to say that if you do have something on the calendar and you have to have some sort of medical procedure, it would allow you to take it and be able to get a continuance so that you could take care of that issue.
And also to piggyback off of that, because I think I mentioned maybe in the first meeting, my husband had cancer and we had chemotherapy treatments every week, the same Mondays, which happened to be my court day. And so I don't know how this would word on being a caretaker or being, the person when we have elders or we have a spouse or a child, how that might work with that. But I do think, most of the time it's such a great group of people that we work with, and judges, they'll understand that. But I don't know how we can elevate those things, because if we are looking at work-life balance, then that is a lot of life. It's taking care of people in our lives.
At the risk of being a contrarian here, I know a lot of employers, including our firm, is looking at getting away from the difference between vacation and medical leave and all, and just going to a leave policy, so that you don't have to question whether somebody's really sick. Do they really need to be out because they're sick, or do they just like Mondays off because they're recovering from a weekend? We have a lot of Monday absenteeism. So I just wonder if we want to go down the why road on secure leave. I'm certainly in favor of extending the days, maybe 4 weeks. And that way, if we do that, we don't have to distinguish between sick leave or family member care or anything else like that. We just allow people more time. If 4 weeks is not enough, I don't know. Bunch of workaholics I see probably on this screen, so maybe people never even taken the full amount of their leave time unless there's been some kind of illness or all. But I just hate to see us get down to whether we think it's a legitimate reason or not. Just makes it simple. you got 4 weeks or 6 weeks or whatever it is, and you can sit home and twiddle your thumbs, or you can be in chemotherapy. It just doesn't matter.
Are there any privacy concerns with having to declare medical versus other reasons for taking secure leave? I mean, would I want opposing counsel necessarily to know that I'm going to be out for something medical? It's just a thought. Again, following up on Walter's comment, medical is important. I think when we did our initial survey, our little tiny internal survey, I had a suspicion that we would find a number of people that would use leave for medical purposes, and I think we had several responses on that, which indicated yes, that was done, and that's important. To what degree can that be different from not necessarily vacation, but attending a wedding of a close friend in a distant place, or things like that? There are lots and lots of reasons people take it. One of the things on our big survey that's going out is we're going to find out a lot of people use secure leave for a lot of different reasons, sometimes religious, other things. And I imagine that it's a real mixed bag, although the bulk of it's going to be for recreation. How do you deal with someone who uses secure leave as basically weaponizes it, though? It's an issue of professionalism. It could bode ill for the administration of justice. Do you have any thoughts on it, or is it? I mean, I think one thing that Mel was mentioning about taking medical, maybe making an exception for it, and it becomes something different altogether. What's the group's thoughts on how you keep secure leave from being weaponized?
I mean, my initial thought is it's, if a lawyer is abusing the secured leave, that should be an ethics violation, and it's something that could be brought before the grievance committee if you're using it improperly or making improper certifications. And maybe we make it even clearer than it is, that you're certifying that you need this time. It's for personal reasons. It's not for purposes of any tactical advantage, and then we would enforce that, through a normal grievance, the way we would enforce other ethics violations. I guess that's my thought. If it's being abused, is we've got a pretty robust attorney discipline process here at the bar, and it's just a matter of figuring out how to, how do we best trigger that or make that clear when people are submitting leave that this is a representation they're doing as counsel.
I was going to say, I agree with Mark, and I agree with what Walter had said earlier, that I don't think from a philosophical standpoint that this is a rule we look at to say, like we do typical lawyers, and say, how is this going to be abused? I think that'll be few and far between. And I just came off a CLE on Friday about the significance of depression and anxiety with attorneys. And this is a fundamental problem we have as a group. And so I would much rather err on the side of being Pollyanna. And if somebody is abusing it, then we let that go up the chain in the grievance, instead of trying to figure out a way to prevent those bad apples. We need to let the rest of the people have some break and know that it's being supported from the top.
I think that's right. And I think the rule as is drafted, there's sort of two important safeguards in there that prevent against abuse now, right? Which is that, you can't designate it if there's already something on the calendar, right? And you can't, and you got to make a statement that, it's not being designated for the purpose of delaying, hindering, or interfering with the timely disposition of any matter. And, now, okay, realistically, a lawyer who's going to unethically designated might not have much of a difficult time making that certification, but it's still a requirement. And then the earlier safeguards probably more powerful, right? If there's already a dep on the calendar or hearing on the calendar, then that's what it is. But yeah, I mean, I agree with what's been said. I think those are probably few and far between. I'd probably rather err on the side of actually rewarding and serving the folks who need it.
The other thing, the other protection is I just pulled down Rule 11, and I think Rule 11 would apply to a false certification of reasons for using it. And if there's some bad actor in a local county, I think a Rule 11 motion might be the solution to dealing with that. It wouldn't require grievance.
Yeah, I think that's right. I mean, I've never encountered anything like this. So I'm just sort of trying to think, on the fly of, what would I do if I were in a situation where somebody, probably pick up the phone and call them and be like, hey, this is just a coincidence, or, what's going on here, and, sort of try to work them out, work it out and discourage them from doing it. If a lawyer got a call like that, they might be so embarrassed where they would just stop and the situation would sort of resolve on its own, right? And I guess if you had to do something more procedurally heavy, yeah, absolutely, Walter. Rule 11 would probably cover you. You could probably, I don't know that you move to strike the designation of secure leave, but there's all kinds of mechanisms where you could sort of get it before a judge who then might, look into it. And if I were a lawyer who were abusing this rule and somebody, filed a something, right, whatever that procedural vehicle is, and got it before the court, boy, I might, rethink what I was doing before I showed up for the hearing on that motion or whatever it was, right? So there's probably a lot of ways to sort of, squash it before it actually, truly becomes a problem.
I agree with you, Drew. On the medical point, I think Walter makes a good point about, do we really want people to have to, figure out what's a medical day versus a personal day? And I am inclined to just give a certain number of days and you can use it as you want. I guess what I'm to Mel's point though, and I think Catherine's point, there should be some mechanism where if I've got a medical need or the chemotherapy, spouse in chemotherapy or whatever, some process where I can make a separate leave request, or maybe it's part of this policy, but it's not part of my 15 or 20 days, where I say, I've got a medical leave, I have a medical need and I need this time off for medical purposes. And it would be voluntary. If you're worried about disclosing it to anybody, you obviously don't have to do it. But I don't even know that we have a process now to make that kind of request where you've got, a procedure coming up or a spouse undergoing something, or you've got some other medical need, and maybe putting some structure around it beyond just going to every judge that you might appear in front of. Again, it's particularly difficult in calendar and call type situations where you don't know what judge is going to hear it. There isn't really a process, unlike if I'm in a case in business court or federal court where I have one judge for the whole case, I could submit a request to that judge saying, I've got this procedure coming up, or my wife's got to do this procedure. Can I get, some protection on the calendar? But for a lot of lawyers, that's not going to be a possibility. And I do think it'd be great if there were some way to do it. And maybe we focus more on process than predetermining how much is allowed or what circumstances are allowed. But we provide some avenue where lawyers who are faced with a medical issue, can make a request to someone at the court level, for consideration or protection.
I'm wondering if we've already got that in the current rule, 26H.
Okay, let me look at that again.
Which says nothing in this rule limits the inherent power of the superior courts or district courts to allow an attorney to enjoy leave that has not been designated according to this rule. So it may be that we've got that covered.
Mark, were you thinking? I agree, Walter. I think that would reaffirm that the court's got the power to do it. But Mark, were you thinking maybe something more explicit, almost sort of like a if you've burned your 3 weeks, and or let me back that up. Rather than having somebody who uses vacation who then has a medical necessity and then needs more, let's take the person who needs 5 or 6 weeks for a medical necessity. Were you sort of thinking about something more explicit in the rule, like almost sort of like a you apply to to the senior resident for an additional 2 weeks for a medical emergency, or medical reasons, and you can sort of decide how you want to state it, cryptically. You don't need to get specific about it, but something like that.
That is what I'm wondering about, Drew. I mean, I agree, Walter, and I've forgotten that kind of catch-all provision that certainly you could certainly go to a court and ask for the leave and they could grant it. I mean, I think that provision allows that. I'm envisioning the person that is looking at this, they know they're going to need some medical time and may not have any or may not want to use the last of their vacation time. I mean, some of these other policies specifically call it vacation time, like the ones we were looking at. This, I think, contemplates not using it for medical, to have some other opportunity or structure around making a request for medical leave. I agree. I'm concerned about saying how long it can be or the conditions that would satisfy the medical leave. I think that's probably beyond our ability to try to craft here, but I'm wondering if a more explicit provision might make sense. And forgive me, my idea is pretty amorphous at this stage. I don't have a concrete proposal of exactly who that would go to or what it would look like. But I think this point about people using up all their leave time because they have a medical emergency or they have to go into, they're in the hospital for 3 weeks or something else, is their only option. And again, if it's last minute, you got hit by a truck and you're in the hospital, you're not going to be filling out any kind of form. So it's not, it's not that you're going to be out for 3 weeks because you got hit by the truck. You're not going to be, doing the forms. But if something's coming and you've got a major surgery coming up and something's on the calendar, the ability to try to provide some advanced protection, makes sense to me that there should be some process. And again, maybe some lawyers now just figure out and make those requests to whoever, senior superior court judge or wherever they're practicing. I don't know if it would be helpful to spell it out a little more for lawyers that have never done it and are, dealing with a lot of other stuff if they're dealing with the medical process.
Yeah, and I think there's, there are a lot of other examples in the general rules of practice, right, where it's sort of, for good cause shown type thing, right? And then you sort of leave it flexible, and if somebody needs more time, they can make that showing. I generally tend to trust our senior resident superior court judges to, determine when there's good cause for something like that.
I mean, I think our message here could be, we think that, if you can't be there for medical reasons, that should be allowed and it shouldn't count against your leave days. I mean, I think that's kind of the premise, isn't it? Separately, if you need medical leave, you should apply for that. And that doesn't necessarily count against the secured leave days here if you apply for and get granted some medical leave. That's kind of what I'm envisioning. So it's our policy position is this is something that, judges should approve or appropriate, and it shouldn't count towards your days. That's what I'm thinking, without maybe going into more specificity. I agree. It's kind of a good question and let them figure it out, but some kind of statement to that effect that would be a little more specific than the current language about judges can do other leave for other reasons, and would specifically essentially recognize and encourage lawyers that know they're going to be out for medical reasons to submit requests if they wish to do so.
Okay. Well, I think this will have to get we have to think through this possible policy creation or articulation in Rule 26 in relation to some of the other rules that we're going to be looking at, like 90 days advance notice. The hit by the truck example certainly would never come up under this, but all kinds of elective surgeries, and by elective, I'm putting quotes around it because there's a big difference between getting that plastic surgery and having to go get a hip replaced, but you've got a little control over when that hip gets replaced. So it is a mixed bag. But I think we're onto something here that's going to be we're going to be bringing it up again and again and again in relation to some of the other rules. I don't want to cut off debate on this one, but I think I've got 3 pages of notes already. Thank goodness. You guys are coming up with some really great ideas. Anything, do we want to, we'll certainly carry this over to the next meeting. Anything else on the medical side of it? I've got a question for Mel that I didn't ask when we were back on that topic, if I may, if that's okay. Mel, with the abuse or potential abuse question, at what point is it an ethics issue, and what point is it a professionalism issue? Should it be more one than the other, or are they, or do both apply? Is there a dividing line? This is your backyard, so I'm looking to you for some guidance.
Well, it would seem to me that a violation that is clearly an abuse. I think the grievance process that Mark made reference to earlier would be in order. We stress the importance of professionalism, and we hope nobody would abuse it. But if somebody is intentionally abusing, I'm fine with the grievance route.
Okay.
And Gordon, if I can jump in, the grievance committee, or actually the DHC, has disciplined a lawyer in the past under Rule 8.4D, which is conduct prejudicial to the administration of justice, for making a false statement on his designation of secured leave, saying, I've got no matters with hearings during this period, and misusing the process to avoid that hearing.
Okay.
Good.
Well, great. That's helpful. Mel, on the professionalism side, what would you do if the lawyer was carelessly or without concern for the administration of justice, cavalierly using or changing or otherwise running fast and loose with the secure leave rules?
Well, as you know, we have the Professionalism Support Initiative, which is confidential peer intervention to deal with unprofessional conduct. And certainly if someone is abusing the leave time, and the reference to Rule 8 violation is good because we want the state bar involved. But if it doesn't rise to that level and it's unprofessional, then we talk about the importance of your reputation, how judges don't forget somebody who abuses the system and lies to them. So I think we still keep both professionalism and ethics involved. It's just which one is serious enough to go to the state bar.
Okay. Okay, I see that. Very good. Is there any other discussion on the leave period as a complete calendar week, which is the portal through which we stepped into Wonderland on this one? We will be revisiting it again in the context of some of these other rules. But we're running up on this 1 hour. Is there any support for extending by 15 minutes? Or are you
I'm available.
everybody content to stop at this point? Does anybody have to get off over the next 15 minutes? Identify yourselves. Okay. Well, let's go on for another 15 minutes and see if we can pick up some more. I'd like to go to B1. There's 3 different leave periods in one calendar year. This is an allied, it's very close to the definition that involves a complete calendar week. Here, the rule is in B1 is that there are 3 different leave periods in one calendar year. And under some of the things that we've discussed about loosening up the strictures for secure leave, this would not necessarily follow if the ability to take secure leave in a 2-day segments or others would happen. So what do you think? And if we can get it in, the second part that's written there, the straddle rule, that if you straddle a year, then your secure leave will be allocated to the year where you took off, but not landed. So if you took off December 28 and into the first week of January, that's allocated to the earlier year. So you basically can't get paid in advance on this one. What are your thoughts? Mark, you've been good today about having thoughts. This is really great. Let's hear it for the Mecklenburg Bar.
I mean, my thinking is that we should go to days instead of weeks, for some of the same reasons I articulated earlier about I don't think there's a magic to weeks. And I would just be inclined to give, a certain number of days. If we keep the 3 weeks, it'd be 15 days. I actually think we should go up to 20. That's a different issue in terms of total allowance. But I think you just get 20 days and you can take them as much, as you want in blocks of at least 2 days each would be my suggestion. I think that's just a lot more flexible for what people need as opposed to saying it's 3 1-week blocks. And I think we can accommodate that flexibility. So that's where I would recommend.
Because some of the earlier comments have anticipated this. What's the rest of the committee think?
I agree with Mark's both suggestions, a 2-day minimum and going to 20 days.
Okay. Others? Dion, Catherine?
I like what Mark suggested, particularly if we do the 2-day blocks and don't call them weeks, so we don't have to worry about having to apportion it to 1 year or the other. I think that's a good remedy for that. And I do think that having more days goes towards what we're hoping to provide for attorneys, which is flexibility.
With regard to the straddle issue, would you just allocate the days to the year? So if you take the last 3 days of December, that goes in that year, and then 4 days in the new year, it would just be allocated to the new year. Yeah. What's everybody else think about that?
That would be my thinking. Yeah, if it's just day by day, you can do it that way. You don't have to worry about the straddle rule. It just is whatever day the year's falling.
Okay.
Yeah, I think going over to days as opposed to weeks makes a lot of sense. I'd be curious though. I always sort of like to know, like what's the policy for the original rule before we start doing too much to it. I'd be curious if Mel, if you were involved in, sort of the original thoughts behind it, or know what the policy might have been for having it to be done by weeks. I'm going to have similar questions about the 90 days too, but I'm sort of interested about, why it was chosen to do it in week blocks like that.
Well, the majority of the discussion involved vacation time, and it was pretty much drawn around the busy trial lawyers who couldn't get away and because of their heavy caseload. The discussion now focuses almost more on things that have come up where it seems that you shouldn't have to take a whole week for a 2-day event or whatever. So I'm glad we're moving to deal with this issue. And I don't think and there was nothing to go by basically when we did it. But I think that if we limit it or go down to 2 days rather than a full week, then you work around that vacation situation, I think, very easily. So I certainly would be in favor of what Mark was suggesting.
Okay. Anyone else care to be heard on this?
I think one other thing that we should consider, and if you want me to do it, I've talked to the Superior Court judge. I still haven't been able to get with the District Court judge, but to find out if they have any thought or input that they would like to make, if they feel that somebody in their district has abused the system, and they want to be sure that doesn't happen again. I think we ought to give the judges an opportunity to be heard on something like that.
Okay. Very good. So if you would do that, that again would serve the function of trying to get these stakeholders an opportunity to react to various things that we're coming up with. That would be great.
Sure, I'll be glad to do that.
Good. All right. Well, Mark has given us some numbers to think about. 2 days on a 20-day leave allowance. This appears to have is supported by those that have vocalized their support. I'm going to assume, unless somebody is bringing up a contrary position or some refinements, that the rest of us on the call are comfortable with working with that for purposes of going through the remaining parts of these rules. Let me, something that I didn't write down on this abstract, but I'd like to consider here, it'll be the last thing we do today, is whether there's any thought to making unused secure leave cumulative. When you think about that somebody out there is going to come up with it. But there may be reasons why. And is there any play in the policy for someone who goes 3 years without vacation because they're planning the grand tour or some type of more serious elective surgery or other things? And unless we at least touch on this, we won't be in position to answer the questions that will come up later. What do you mean I can't carry over my leave? Well, you can't now, I guess. It's the way it's written. But since we're considering all of this, what are thoughts on accumulation of some of the leave?
I mean, I would love it. But I think that it runs into an administration issue would be my concern. I mean, I just think of it for other people who work your more typical job, you have an ability to bank so many days over a year. And it seems like every employer has a different sort of process. And so we could set, some ability to have a carryover, but I wonder if it then becomes just sort of an administrative nightmare of somebody keeping track of something, and it may just be something that we want to say specifically can't, or won't be accumulated. Though I would love it. I just think that that's going to be a court problem. And you're just going to have to make other plans if you want to take 3 months off for the grand tour.
Yeah. Yeah.
Even though I'm a lover of the grand tour, I agree with Catherine. I think I think it'd be difficult, and I would worry about, if you want to do the sabbatical, I can give you tips on that for the time to do the 3 months, but I didn't use secure leave for 3 months. But I'd worry too about lawyers that don't take it for 3 years and then just come in and say, okay, I'm now ready, for that whole period of time. I just think that's it's going to be a huge burden to track it. And then you got someone that's out for 3 months, and that is a problem for administration of justice a lot. So I think that probably is not a good, not a workable idea. At least that this would be my view.
Others? Drew?
I'm against grand tours.
Yeah, I mean, I should say, Gordon, I don't have any thoughts that haven't already been shared. I mean, I agree with everybody on this one.
All right.
I think it's fairly straightforward.
Okay. Mel, you want to weigh in on this?
No, I agree with what everybody else has said. I'm not in favor of carrying over months.
Okay. Shelley, any matters we've talked about today, something you want to comment on? I know you're the fresh lawyer on the block.
I appreciate everyone's comments. And I mean, I agree with duration shorter than a week. I think 2 days is good. I agree with much of what's been shared. And while I'm pro grand tours, I think they can be accomplished in 20 days or less. So if we go to 20 days, I think that would be doable.
Very good. Very good. Okay. We've started the abstract. I'm going to, I think we've gotten comment on this last item. I wanted to sneak in there about accumulation. Again, I think it's unwieldy. And I think if you're going to take the grand tour, you can probably handle it by hiring more associates. So we can deal with that other ways. Let's do this. Is there anything else to come before the committee today? We've got a lot to look forward to in terms of getting results back from the internal poll of the State Bar Council, which will ultimately be part of the regular poll. I know that Cameron's going to continue looking for guidances from other jurisdictions. Savannah's going to be taking the helm with the, I think, with the actual deployment of the survey. So there's going to be a lot happening, and they've got a lot coming up themselves with their day jobs, with hearings and things like that. So we're going to have a busy time. We'll send out a notice for a very early June meeting where we can not only get reports of what has been done over the intervening month. You will probably have the survey results before that, as for the State Bar Counselors. And then we will continue going through this abstract and working on each one of these rules and seeing what we're coming up with. I am very, very appreciative of the thought everybody's given it and willingness to speak out on it. I don't do a lot of this, so I never really knew how the meatloaf was made, but we're making some pretty good meatloaf, folks. I've already got the feeling and on this, and it might be worthy of consideration for adoption statewide if we keep on this kind of vector and bring it into the way people practice and live these days. So is there anything else to come before the subcommittee? We'll meet our 1 hour and 15-minute adjournment deadline.
Gordon, I figured out how to raise a hand there. I actually raised a hand.
Oh, I'm sorry. I missed that.
I'd just like to throw one other thing out for consideration, and that is how to file your notice. We now have a statewide online calendaring system, and I'm wondering if there's not some way we can tie into that. Because for those of us who practice across the state in multiple jurisdictions, it's a pain in the neck. And the other thing I don't know that we put on the agenda is the appellate courts, because they have no secure leave provisions.
Yeah, appellate will be on the agenda because our charge is to do both the trial courts and the appellate courts. And Drew is going to be our guide on this because of his service on the appellate committee currently, and I think he's got an in with the Barbara Jackson, who's coming on to lead that. That'll be a source of also some feedback for us. But we'll definitely make sure we get that on. And Walter, I think the idea about how to file the notice, that may get some traction. What do you know? I'll make sure I'll amend the abstract to put that on there as a definite item to be discussed.
Gordon.
Anybody else have Drew?
Yeah. Hey, Gordon, really briefly, Walter, on your good thought about an electronic notice. So the appellate courts do have secured leave, and for once, maybe they're a little bit ahead of the trial courts in how easy it is. So it's an electronic system. I can't remember exactly when they went over to it, but it's literally as easy as, pulling up the web page, typing in your name, typing in the dates, it gets sent, and then that's it, for both appellate courts. I mean, I'd love to see something like that in the trial courts, because Walter, my practice is like yours. I mean, I'm in, Allegheny, or I'm in New Hanover, and it's like, if I could streamline it. Sometimes, I mean, frankly, sometimes I don't even pursue secured leave because it's just too much of a pain, So I'd love to see that change.
Well, I'm glad to learn about the appellate court because I had no idea.
Yeah. Well, we'll make sure that those are in the abstract as we keep working through it at the next meeting. So if there's nothing else, everybody have a good May. We'll be in communication throughout the month, and then we'll be meeting again in early June sometime. If Savannah will send out a poll, and we'll get that done. If there's nothing else, then let's declare this meeting adjourned, and we'll see you anon.
Thanks so much.
Thanks, everyone.
Great seeing everybody.
Bye.
See y'all.
Mark.